Before we get started, let's be clear about some important facts. This video does not guarantee that you will get custody or visitation. Before you file for custody or visitation, be aware that the judge will determine who will have custody of your child and what visitation rights will be allowed. The judge may not follow your wishes or recommendation. Once you file for custody or visitation, the other parent can hire an attorney and fight you in court. And the legal process for gaining custody or visitation rights can be very time-consuming and complicated. If you or your child is a victim of domestic violence, or if Child Protective Services is involved with your family, or if your child lives in another state, or if the other parent is on active duty in the military, we strongly advise you to consult with an attorney before making a decision about filing for custody. If there is already a custody case that concerns the child over whom you want custody or visitation, then this video will not help you. You should consult an attorney to determine what action needs to be taken. This video is the first in a two-part series about how to represent yourself in a custody case. This first video is going to show you how to file for a custody or visitation order from the court and how to prepare for mediation. The second video will explain how to prepare your case for trial. Our presentation is divided into 6 sections. Overview will briefly explain how the court will make its decision and the meaning of some terms like joint custody or sole custody that are used by the court. Where to file will tell you how to decide the correct county where you should file for custody. Filling out the forms will show you how to fill out the forms that are needed to start your custody action. Filing the forms will tell you how and where to file your completed forms with the court. Giving notice will tell you how to let the other person in the custody or visitation action know about the case. The law requires that this notice be given in very specific ways. Mediation will describe the mediation process you will take part in and give you some suggestions for preparing for the mediation. We will also tell you what happens if the mediation fails to get an agreement between you and the other person involved in your case. Overview. In North Carolina, if you file a custody or visitation case in court, a district court judge will make the final decision about who gets custody and what visitation is allowed. If an agreement is not reached during mediation, then there will be a court hearing.
Let's come to order. Calling the first case, Janet Hall Thomas versus Richard Craig Thomas. Parties come forward.
The judge will listen to testimony from witnesses, including you and the other person involved in the case. The judge will also review evidence. The judge will then decide what is in the best interest of the child.
Okay, I'm ready to make my ruling.
In deciding what is in the best interest of the child, the judge will consider many things, including parenting ability, family stability, criminal backgrounds, the performance of the child in school, and each person's ability to provide basic care for the child's health, education, and general welfare. Settling your case at mediation is quicker than having a court hearing and gives you more say in the final decision.
Might be helpful in some ways with that. But again,
when one parent sues another for custody, the law does not favor the mother or father in making a decision about custody. The judge will decide what's best for the child. The judge will decide who will make the major decisions in the child's life, such as health care, education, and religious upbringing. This is called legal custody. Joint legal custody allows both parents equal decision-making rights. Primary or sole custody allows just one of the parents to make all of the major decisions. The judge will decide where the child lives and how much time the child spends with each parent. This is called custody and visitation. Grandparents, relatives, or even persons raising children who are unrelated to them can get custody. In order to gain custody, they must prove that the parents have abused or neglected their children, or that the parents acted inconsistently with their rights as a parent. An example of this type of behavior would be when a parent leaves their child with another person for a long period of time without communicating with the child. Where to file. To begin your custody case, you will need to file a lawsuit. You can file a lawsuit in North Carolina if the child has lived in North Carolina for the past 6 months, or if the child is less than 6 months old and has been here most of his or her life. In all other situations, see an attorney to find out where you should file your case. Once you have determined that you can file the case in North Carolina, it is important that you file your case in the right county. You may file in the county where the child lives or in the county where you live. Filling out the forms. There are 2 forms that are needed to file your custody case. These forms are the complaint and the civil summons. You may also need to complete other forms, such as the petition to sue as an indigent and an affidavit of return of service by certified mail. We're going to look at each form and explain how to fill out each section of the form. Please do not fill out any part of the form until we get to that section. Let's begin with the complaint. We will start from the top of the complaint and work down. In the top left-hand corner is the State of North Carolina, County of blank. Fill in the name of the county where the custody complaint is going to be filed. In the right-hand corner is a space for the file number. Do not put anything there. The clerk of court will put in a number when you file the case. Let's move over to Name of Plaintiff. Put your full legal name here. The plaintiff is the person filing the complaint. There can be more than one plaintiff. Next is Name of Defendant. Put the defendant's full legal name here. If you are the parent of the child, then you must name the other parent as the defendant. A parent means either the biological or adoptive parent. If you're a non-parent of the child, then you must name both parents as defendants. There can be more than one defendant. Next, on the right side after Complaint For, check the box for either custody or visitation. Now, let's go to the numbered paragraphs. Number 1, fill in the county and state where you live. Number 2, fill in the county and state where the defendant lives. Number 3, check the box that describes your relationship with the defendant. Number 4, list the full names of the children who were involved in the case. Number 5, first child. Fill in the name of the child and the child's date of birth. In Section 5, you will list all of the places the child or children has lived for the past 5 years. You may have to use additional pages if the child has lived in a lot of different places. On the first line, put where the child is living now. Write in the date he or she began living there. Write the name of the person with whom the child lived and the address where that person is now living. Continue until you have listed all the places where the child has lived in the last 5 years. Turn to page 2 of the complaint. Check the first box if you have already been in a lawsuit as a party or witness for custody of this child. If you check the box, write the name of the court, the case file number, and the date of the decision. Check the second box if you know that there is another lawsuit concerning the child going on in North Carolina or another state. This may mean a domestic violence case, termination of parental rights case, an adoption, or a criminal charge involving abuse or neglect of a child. If you check this box, write the name of the court, the case file number, and the type of case. Check the third box if you know a person who is not named in this lawsuit who has physical custody of the child, or who claims custody, or who claims visitation rights to the child. If you check this box, fill in the name and address of this person. Repeat this information for each child and attach additional pages if necessary. In paragraph 6, check the box for custody if you want primary custody, or check the box for visitation if you want visitation. You do not need to fill in anything in paragraph 7. In paragraph 8, check only the box that applies to your case. If your child has lived in North Carolina for the past 6 months, check the first box. If your child is 6 months old or younger and has lived in North Carolina since birth or for a majority of his or her life, then check that box. In the final section that begins, "Wherefore the plaintiff prays of the court," check only one box. Check the box for temporary and permanent custody if you want custody, or check the box for temporary and permanent visitation if you want visitation. Fill in the date you're signing the complaint. Place your signature on the line that says Signature of Plaintiff. Print your mailing address on the 2 lines on the bottom right of the page. Place your telephone number on the bottom line on the left of the page. Page 4 contains the verification. You must sign the verification in front of a notary public or clerk of court. You can often find a notary public at a bank or a legal aid office. Sometimes someone in the clerk of court's office can notarize your document. The notary will want to see your driver's license or some other form of identification with a photo. You may need to pay the notary public a small fee. At the time the verification is notarized, you can fill in the county name at the top left of the document. Print your name on the first line of the verification, fill in the date, and then sign your name on the line that says Signature of Plaintiff. The notary will fill in the information below your signature. The next form is the summons. This is the form that will be given to the defendant along with the complaint. Leave the top right file number blank. The clerk will fill it in. Under the file number are boxes for either the Superior Court or the District Court. Check the District box. On the top left, put the county where you're filing the complaint. In the box for name of plaintiff, write your name just as you did on the complaint. Now fill in your address in the boxes labeled address, city, state, and zip. In the box for name of defendant, write the names of all the defendants as you did on the complaint. In the box labeled Name and Address of Defendant 1, write the name and address of one of the defendants. In the box labeled Name and Address of Defendant 2, write the name and address of the other defendant. In the box labeled Name and Address of Plaintiff's Attorney, if none, the address of the plaintiff, fill in your name and address. Leave everything else on the form blank. The next form is the petition to sue as an indigent. You will only need to fill in this form if you do not have the money to pay the court fee for filing the complaint. On the upper left of the page, fill in the county and write the names of the plaintiff and defendant exactly as they are listed on the complaint you filed. On the top right, check District Court. Check the box next to Petition to Sue. The next set of boxes help the court decide if you're entitled to file the complaint without paying a fee. Check the first box if you receive food stamps. If you receive AFDC, TANF, or Work First, check the box labeled Aid to Families with Dependent Children, AFDC. If you receive Supplemental Security Income, SSI, check that box. Check the box for each type of assistance you receive. If you are representing yourself in this case, you should not check the box that says you are represented by a legal services organization. If you do not receive any of these forms of assistance, but believe you are not financially able to pay the filing fee, check the last box. You must sign the affidavit before a notary public or a clerk of court. Filing the forms. After you have completed the forms, you will need to file them with the clerk of court's office in the county named in the complaint. Bring your original and at least 3 copies of each form. If your income is too high to file as an indigent, you will also need to bring cash money to pay the filing fee. You should call the clerk's office to find out the filing fee and whether a notary is available.
May I help you?
Yes, I need to file a complaint.
You must file your case in the office of the clerk of court at the county courthouse or judicial building.
Okay, have you filled out a summons?
Yeah.
In order to start your custody case, you must file a complaint and civil summons. You have the right to file these papers without having a lawyer.
Thank you. I also need you to fill out a domestic action cover sheet.
Many clerks also require a form called a domestic action cover sheet. It was not included in your packet, but please fill one out if requested by the clerk.
Okay, these look in order. I need your filing fee.
I can't afford a filing fee. Is there any way I could file without paying?
Do you receive TANF, Work First, AFDC, SSI, or food stamps?
No, but I do have a petition to sue as an indigent.
You are required to pay a filing fee unless you are approved for free filing by the clerk's office. Call the clerk's office in advance to find out the cost of filing. If you receive TANF, AFDC, Work First, SSI, or food stamps, you qualify to file for free.
Place your left hand on the Bible, raise your right. Do you solemnly swear the testimony on this petition is true to the best of your knowledge and belief, so help you God?
If you do not receive Work First, TANF, AFDC, SSI, or food stamps, you may still qualify to file the complaint without paying a filing fee. If your income is low enough, you can ask the clerk of court to approve your petition to sue as an indigent form. You may need to fill out an affidavit stating your income and living expenses.
I need 3 copies of your complaint and summons.
When you file your complaint, you will need the original and enough copies for the court and everyone named as a defendant and yourself. The clerk will stamp the original complaint and the copies. She will keep the original and return the other copies to you. The clerk will then fill out the civil summons form. The summons is a document that accompanies the complaint and informs the defendant that he or she has been sued. You will need to provide the clerk with 2 copies of the summons for every defendant.
What do I need to do to have a mediation or court date set?
Court dates are set by our family court, and that is...
Some clerk of court's offices will set the court date or mediation date when you file your case, and other clerks will require you to set the date or may direct you to the family court office for these questions.
May I help you with anything else?
No, that's it.
Giving notice. The law requires that you give a copy of the summons and complaint to all of the defendants. Giving a copy of the summons and complaint to the defendant is called serving the summons and complaint. You must have proof that you serve the summons and complaint when you go to court. There are several ways to serve your summons and complaint. You can have the sheriff serve it for you. You can serve it by certified mail, return receipt requested, or you can serve it by placing an ad in the newspaper. Service by the sheriff is the best option when you know where the defendant lives. You will need to call the sheriff's department located in the county where the defendant lives and find out how much they charge to serve the complaint.
Hello? Yes, I was calling to see how much it costs to serve some papers.
Even if you were allowed to file your complaint as an indigent, you may still have to pay to have the complaint and summons served by the sheriff. However, the cost is much less than the filing fees. Once you determine the amount of the service fee, you will need to take the complaint, summons, and money for the service to the sheriff's office. In some counties, the service fee is paid at the clerk's office. If you cannot go in person, you may mail the documents along with a request that the sheriff mail the completed summons to you once they have served the defendant. Be sure to include a self-addressed and stamped envelope so that the sheriff can mail you a copy of the completed summons. Also include a money order or certified check to cover the service fee. Sheriff's offices generally do not accept personal checks. Another way to serve the defendant is by sending all the filed documents by certified mail. You will need to request a green return receipt postcard signed by the addressee only. You can do this at your local post office. The post office will charge you a fee for certified mail and the green return receipt postcard. When the post office delivers your letter, they will have the defendant sign the return receipt. When you receive the signed return receipt, you will need to complete an affidavit of return of service by certified mail and have it notarized. You will then need to take the affidavit to the clerk of court's office to file. Filling out the affidavit of return of service by certified mail is easy. On the upper left of the page, fill in the county and write the names of the plaintiff and defendant exactly as they are listed on the complaint you filed. In the upper right-hand corner, put the file number that the clerk put on the complaint when you filed it. Below the name of the defendant, put your name in the blank space. In the paragraph numbered 1, no entries are required. In the paragraph numbered 2, write in the address where you sent the civil summons and complaint to the defendant. That address should be the one from the green return receipt postcard. In the paragraph numbered 3, write in the date that the defendant signed for the mail. That date is located on your green return receipt postcard. Be sure and double-check that the defendant has signed the return receipt postcard. Then staple the green return receipt postcard to the affidavit. Finally, fill out the information with the date and your address, but do not sign the document yet. The document must be signed in front of a notary. The original affidavit and copies will need to be filed with the clerk of court. A copy will need to be mailed to the defendant. If you do not know where the defendant lives, you can serve him or her by publication in the newspaper. The requirements for what must be in the notice and how long it must run are very complex. You should seek the assistance of an attorney to serve the defendant by publication in the newspaper. Mediation. Before the judge hears your case, you and the other parent or guardian will be required to attend a mediation session. The purpose of the mediation is to give you an opportunity to reach an agreement about sharing time with the child and to determine how decisions will be made regarding the child. The mediation sessions are generally held in a room at the courthouse where your case was filed. You will not be charged for the mediation. The only people present at the mediation are a trained mediator, the other parent or guardian, and you. No lawyers are present. Mediation is good for 3 reasons. 1, you and the other parent or guardian, not a judge, decide what time the child spends with each party and how decisions are made for the child. 2, your case can be over sooner than going to trial. 3, mediation is less stressful and formal than a trial. The agreement you reach is called a parenting agreement.
Good morning, my name's Catherine. I'll be your mediator today. Did you go to an orientation, both of you?
Before you have your mediation, you must attend a group orientation where a mediator or court official will explain what happens at mediation and show you a video so you will understand the process a little better. Other people who are mediating their cases, including the other parent or guardian of the child, will be at the orientation with you. Nothing about your specific case will be discussed. The orientation is only to help you understand what will be happening when your own mediation session is held. You will receive notice about the time and place for your mediation. Before you leave the orientation session, make sure you understand how the date and time of your individual mediation session will be set. Before you attend the mediation, write down what you think is the best plan for sharing the child's time between you and the other parent or guardian. Remember to consider the child's school schedule and the work schedules of the child's caregivers. Think about how you want to share the child's summer vacation and holidays. You may take this list with you to the mediation. The aim of mediation is reaching a decision about how to share time and responsibility for the child. Be prepared to be flexible so that the best decision can be made for your child. If you come into the mediation with the idea that you will not change your mind no matter what the other person says, you may never reach an agreement. Mediation is a give-and-take process. Be ready to compromise. When you arrive on the date of the mediation, you will meet in a private room. The mediation will be run by the mediator.
Let me remind you what we're going to do today is make decisions about James and what's best for him. Remember that I will not make the decisions for you. I'm going to help you make the decisions yourself about what is going to happen in the future for James.
Only the parties are allowed to attend the mediation. The mediator does not take any person's side in the mediation. The mediator is an impartial, trained professional whose only job is to help you both reach an agreement.
Where is James living most of the time?
James has lived with me his whole life. I've been the one taking care of him, and I want him to stay with me.
I'm working second shift, so I'm away from home in the afternoons and the evenings. But I really want to be a part of James's life.
The mediator will not decide who is right or wrong or force anyone to agree to anything. Here are some good rules to remember.
Richard, how much time do you spend with James now?
I'm working second shift, so I'm away from home in the afternoons and the evenings. But I really want to be a part of James's life.
Listen to what the other side is saying, just as you want them to listen to you.
Janet, what are your thoughts about James having time with his dad?
Richard wasn't there when James was sick. Why should he get to be there when things are going well?
Well, let me ask you, do you think there's any benefit to James to be with two parents who both love him?
I guess so.
Focus on the problem, not the other person. It is the time to think about the future, not the past.
Let's talk about the holidays. Christmas is coming up, so we'll start with Christmas. What are your thoughts, Richard, about time with James on Christmas?
I want James to eat Christmas dinner with me and my mom.
No. He'll be spending Christmas with me all day.
Why can't we both spend time with him on Christmas?
Do not dig your heels in. Think about what the child needs, not about getting everything you want.
Parents have lots of decisions to make about children's lives. If James starts kindergarten next year, where will he go to school? How will you make that decision?
I should have some say in that. No one's even ever asked my opinion, and I'm the boy's father.
Do not interrupt the other person when he or she is talking.
Well, what do you think, Janet? How should the decision be made?
Each person will have plenty of time to talk and express their views.
I've had to make every decision by myself. I want what's best for James. And I guess I can talk things over with Richard, but if I do, he needs to help out.
I haven't spent a lot of time with James in the past, but I've changed. I've got a new job, and my mom has even offered to help out.
Be respectful. Avoid blaming or putting down the other person. Each person takes turns telling the mediator how they want to share time and responsibility for the child. The goal of mediation is to agree on a plan that is best for the child.
You agreed that James will live with his mom during the week. So let's talk about how he might spend time with his dad. Richard, what are your thoughts about a schedule you might have and how you're going to spend time with James on the weekdays and the weekends?
Look, if James gets to spend all week with her, then I think I should at least get him on the weekends.
I work all week. The weekends are my special time with James. And on Sundays, I take him to church. I want him to be with me in church on every Sunday. It's fine if Richard wants to visit with him for a couple hours on Saturday, but it needs to be at my house.
See, that's not fair. I want to take him places and have him spend the night with me. He's my child.
Even if it looks like you and the other party can't agree, keep trying. The mediator will help you find a compromise that works. Remember, mediation is usually quicker than going to court to get a decision. By reaching an agreement, you can avoid the possibility that the judge will rule against you. Many people find mediations less emotional and embarrassing than having to testify in court.
Well, Janet, what would Richard need to do so you'd feel comfortable with James spending the night?
I want them to spend more time together during the day before I'd feel comfortable with him spending the night at his father's house.
Does that make sense to you, Richard, that he'd be with you during the day first before he stays the night?
I guess. But I do want him to spend the weekend nights with me at some point.
You've agreed that James will be with his dad every other weekend and one evening during the week. Do you have any other concerns about the schedule?
I don't think I should have to pay child support for the time he's with me.
Well, child support is one of the things we can't talk about in mediation.
Child support issues cannot be discussed or decided at the mediation.
You've agreed on decision-making power. You've agreed on where James will reside during the week, on the schedule for the month. You've agreed on the holidays and the summer. Are there any other issues?
Before the mediation is over, check the notes you made to make sure that everything you wanted addressed was discussed.
No.
You did a great job today. You made all the decisions that were necessary to put into a parenting agreement, and James is going to benefit from that. What I will do is put together a draft, and I'll mail you a copy of the draft. Be sure to...
If you and the other party can reach an agreement, the mediator will put the parenting agreement in writing. It varies by county, but many mediators will send the agreement by mail to each person. When you receive the agreement, review it and make sure there are no errors. Do not make any changes to the agreement if there are errors. Contact the mediator. If the agreement is correct, then sign it and send it back to the mediator. Your agreement is called a parenting agreement. Once the agreement is signed by you and the other party, the mediator will present it to the judge. When the judge signs the parenting agreement, it becomes an official court order. Since the agreement is a court order, once the judge signs it, if either side wants to change the parenting agreement, that person needs to file a motion to modify the agreement. The court will send the parties to mediation again to see if they can agree to a change. If you or the other party fails to follow the parenting agreement, then the other party can file a motion or written request in court to ask the judge to require the other party to come to court and explain why the parenting agreement was violated. The court can ensure that the order is enforced.
Looks like you're not going to reach an agreement today.
Not all mediations end in an agreement. If you cannot reach an agreement at mediation, your case will go to trial, and the judge will decide custody and visitation. It is strongly recommended that you seek the assistance of an attorney if there is no agreement reached at mediation. There is nothing more important than your child. Every decision you make about custody and visitation should be based on what is best for the child. We hope this presentation has given you the information you need to get the custody and visitation plan that is best for your child. As with any legal action, we cannot guarantee how your custody case will turn out. If you're unable to reach an agreement in mediation, a judge will decide your case, and you will probably need an attorney to represent you in court. Legal Aid of North Carolina, however, will not be able to provide such representation as it generally has too few staff and insufficient resources to be able to provide attorneys for custody matters in court. To find an attorney to represent you in court, you can call the North Carolina Lawyer Referral Service at 1-800-662-7660. That service will give you the contact information for a local attorney in your area who handles custody cases. The referral attorney will discuss your case with you for 30 minutes for a $50 fee. We hope this presentation has been helpful. For more information about the services that can be provided by Legal Aid, go to our website at www.legalaidnc.org.